As for the introduction, the issue here is to whether Dino can rely on the exclusion clause stated in the terms and conditions in order to exclude the liability of paying for the damages suffered by Chinta. Whether Chinta could claim damages from Dino resulting from the stolen car due to Dino's negligence and the hidden manufacturing defect that was installed by Dino, causing Chinta to sustain a broken leg and a badly damaged back. To identify the parties in this case, the potential plaintiff in this case would be Chinta and the potential defendant would be Dino.
Assalamualaikum to Dr. Normawati. My name is Nur Amalina Liana binti Muhammad Ali. My metric number is A190126. I will discuss the first issue in Cinta and Dino's case. Before that, let me define what is an exclusion clause. In the case of CIMB Bank Berhad and Anthony Lawrence Burke and another, exclusion clause is a contractual clause or terms that limits, excludes, or alters the party's duty, liability, or remedy. The first issue between Cinta and Dino is whether Dino can rely on his exclusion clause to avoid paying for Cinta's damages. In this present case, the exclusion clause was found in an unsigned document. As the situation does not indicate any evidence of the parties having signed any document pertaining to the service of the vehicles. Dino's exclusion clause must meet three elements for it to be reliable, valid, and binding. For the first element, the unsigned document which state any exclusion clause must be of contractual in nature for it to be binding. This is shown in the case of Chapelton and Barry. In this case, the damages were awarded to the appellant because the clause given on ticket is not valid due to it was given after the contract was made. The court regarded that the ticket cannot be regarded as a document that contains contractual terms. In Dino's situation, the unsigned document is contractual in nature. This is because large service providers, such as vehicle services, typically require contractual terms to ensure the provision of essential services in hopes it will be reliable in order to exclude any liability on them. Hence, Dino has successfully fulfilled the very first requirement or element stated in the unsigned document.
Next, it is crucial for the exclusion clause to be deemed reasonable as we may look at the case of Parker and Southeastern Railway. In this case, Parker claimed he had not seen the notice in the clockroom or read the ticket stub, but had simply placed in his pocket thinking it was receipt for his deposit goods. Because the defendant adequately informed the plaintiff about the clause, the court found the defendant not legally liable. All efforts were made to ensure that the exclusion clause, as mentioned in the ticket and the notice in the clockroom, was duly acknowledged. Thus, in Dino's situation, the exclusion clause found in the terms and conditions is inadequate and unreasonable, similar to the facts stated in the Parker and Southeastern Railway case. This is because no car owner expects the terms and condition to be as strict as Dino's first term, which state that all vehicles are left at the customer's sole risk, and Dino shall have no liability for any vehicle which is stolen while on the premises. Additionally, Dino failed to expressly state the terms and conditions to Cinta and neglected to provide any notice regarding the clause. Instead, Dino solely relied on the terms and conditions of business liability. In addition to that, due to Dino's negligence, had caused the theft of the Ford car and the involvement of the Vauxhall car in accident, resulting damage to the vehicle and a broken leg to Cinta. Hence, Dino failed to meet the second criterion of the exclusion clause, since it is totally unreasonable and inconsiderate to include such provision in the contract.
Moving on to the third element to be fulfilled is that the document containing the exclusion clause should be provided either before or at the time when the contract is being agreed upon. Failure to do so will result in an exclusion clause being non enforceable. We can refer to the case of Orly against Marlborough Court Hotel as an example. In this case, the plaintiff was a guest at the defendant's hotel and had lost her belongings in her hotel room. The defendant tried to rely on an exclusion clause mentioned in a notice inside the room, stating that they wouldn't be responsible for lost or stolen items. However, the court ruled that this exclusion clause couldn't be enforced because the contract had already been formed before the plaintiff had the opportunity to read the notice containing the clause, which was inside the hotel room. Just like in Dina's situation, the exclusion clause was presented to Chinta after she had already experienced losses. Thus, the third element is also not fulfilled. Dino had not fulfilled two of three elements for the exclusion clause to be established. Hence, Dino could not rely on the exclusion clause. However, if the terms in question are unclear, the contra preferentum rule could be applied. Referring to the case of Baldry against Marshall, it establishes that if an exemption clause in the terms and conditions is not clear or contains ambiguities, the rule is that it will be interpreted against the party trying to use it for their benefit. Dino's terms and conditions are not clear regarding the exact replacement cost stated in the contract. The contra preferentum rule states that if one party includes a clause in a contract that appears to undermine the primary purpose or objective of the contract, the court may disregard the clause. This principle is used in the case of Sherhai Tong Bank Limited and others against Rambler Cycle Co. Limited. In Dino's case, the terms of the contract he provided seem to undermine the main purpose of the contract, especially since the damage to both cars and the injury to Chinta is resulted from Dino's own negligence.
In the case of Chin Huinan against Comprehensive Auto Restoration Services and Jan Berhad and another, it was stated that clear and unambiguous words are necessary to protect a person from liability for negligence if negligence is involved. In this case, the appellant had on payment of Ringgit Malaysia 295 to the respondent agreed to have his car washed and polished by them. The appellant left his car at the respondent's premises in the basement of a shopping complex and was given a receipt with which to claim his car. When the appellant returned, he found out that the car was damaged because the respondent employee drove the car and the appellant sued. However, the respondent relied on the exclusion clause in the receipt stating that the company is not liable for any loss or damage whatsoever of or to the vehicle, its accessories or contents. Vehicles and goods are at owner's risk. By doing so, the court decided to uphold the High Court's ruling that an exclusion clause that is broad and generic does not absolve the respondent of the responsibility of demonstrating that the damages to the car were not caused by the negligence or misconduct. The respondent must demonstrate that they handled the car with care and diligence. In this instance, the respondent had fallen short of meeting that obligation. The claim for depreciation was denied because it could not be proven. However, the court approved the claims for repairs, the expense of renting a replacement vehicle, and paying the adjuster. Regarding this instance, Dino may be accountable for Chinta's damages because Dino failed to perform his duties as a vehicle servicer with due diligence and care, which means that Dino was in violation of his obligations to regulate himself. Even though it is totally Dino's fault and negligence, the exclusion clause specified in Dino's terms and conditions has removed Dino's liability.
In conclusion, we recommend applying the contra preferentum rule, which favors a more reasonable interpretation over enforcing the exclusion clause in unsigned documents, given concerns about its insufficiency and lack of clarity. Dino's provided clause entirely absolves him of liability, making it questionable in a legal context. Based on the balance of probabilities and supported by legal precedent, we believe that Chinta has a stronger case for application to be upheld by the court. Therefore, our advice to Chinta is to pursue legal action and claim damages from Dino. His failure to meet contractual terms and negligence in securing the Ford car and causing defects in the Vauxhall car should weaken his reliance on the provided limitation clause. That is all from us. Thank you.